I'm Jeff Butler of the Butler Law Firm. Today we'll talk about responsibility for tractor-trailer accidents. In most cases under the law, when one person is working for someone else and doing work for that person, when he or she causes injuries to a third party, then the employer is responsible to that third party. In other words, that employer has to compensate the third party for the injuries that he or she sustained because they occurred while someone was doing work for that employer. That principle is called vicarious liability or respondeat superior. Now, in the context of tractor-trailer work and trucking companies and trucking accidents, oftentimes big truck companies try to get around that. They want to not be responsible for the injuries caused by drivers who are hauling their cargo across American highways. To do that, they often try something called the, quote, independent contractor, end quote, defense. And while that defense may work, in some cases and in some contexts, in the context of a tractor-trailer accident, it is almost always BS. That's true for two reasons. First, when the big company claims to lease someone else's, like a small fly-by-night company's truck, or claims to borrow or hire that driver for a short term, that's usually on a lease, and it must be made pursuant to the Federal Motor Carrier Safety Regulations, a body of federal law that governs this area. And pursuant to FMCSR, Federal Motor Carrier Safety Regulation 376.12, the company that's leasing the truck assumes, quote, complete responsibility, end quote, for injuries caused by that truck. The second reason is under Georgia law, the driver of that truck is a, quote, statutory employee, end quote, of the larger company. A case in Georgia saying that is the PN Express against Zagel case, which you can find at 304 Georgia Appeals 672.